Kimberly says, what if you don't like the way my lawyer is handling things and I want to hire somebody else instead? Is that an easy thing to do since I've already signed a deal with him? Now that sounds like a question a lot of people will want to know the answer to.
Okay, Kate, you take that.
Okay, well, the short answer is yes. You can handle. I mean, you can fire your lawyer. You have the absolute right to hire and fire anybody you want. That being said, a lawyer who has undertaken to represent you is entitled to a fee for their work done and their costs put into the case. So should they hire another lawyer, they also have a right to file a legal lien on your claim or your settlement for the work done.
Okay. All right. So let me ask this question then. Does that if they only worked maybe a week, can they put a dollar amount on just a week or the whole case?
It doesn't quite work that way. I mean, Kate's right. The attorney who has had the case can file an attorney's lien for whatever work they've done on the case. The way it is normally handled, in fact, we had one just within the last year where a client came in, he had a lawyer, he was very unhappy with that lawyer, but he was friends with the lawyer, so he didn't want the lawyer to get hurt, but he wanted to discharge him from further activity on the case. So he came in and talked to me, I looked at it, and let me add this too. The client can, as Kate says, she can hire or fire any lawyer that you happen to retain. But you should be with some cause. We have had clients come in who wanted to discharge a lawyer because they felt like the lawyer wasn't doing what they should have done. And we always advise them that they have to bear in mind that 95% of everything that a lawyer does on a case, especially a damage suit, is done without the client's knowledge or presence. So the client oftentimes is not really aware of what the lawyer has done or not done. We, as a matter of course, in this firm, if somebody comes in and they have a complaint like that, we first look at who is the lawyer. If it's a lawyer whose reputation we know to be a lawyer who is in good standing and does good work, we talk with them, counsel with them, and then we call the lawyer that they want to discharge and try to get to the bottom of it. And I would say the majority of the time, we suggest that the client go back and talk to that lawyer, because I would say in most cases, it is a breakdown of communication. And if we can get, now the failing on a lot of lawyers' parts is they don't communicate as they should with the client. But if you can get past that and it's a good lawyer and he's done the work he should have done, they'll go back and mend their differences and he'll continue with the case. If the complaint is valid and the lawyer hasn't done the work that he or she should have done, the client can discharge that lawyer. The receiving lawyer then would contact the fired lawyer and find out what has been done and what claim that lawyer might have on the case. So whether it was 1 day, 1 week, 1 month, 1 year, in some cases 2 years, you look at what the lawyer has done in advancing the client's cause. And they then must show what time they put in it, what effort they put in it, and what they've accomplished in the time they've had it. The more they can show, the more fee they're entitled to. And that comes under the heading of something called quantum meruit. That's a concept that they could be paid for the work they've done and file the attorney's lien with the court. Mm-hmm. And that sometimes is the way it's handled. However, in most cases, certainly in our firm, if that's the case and the lawyer's done an okay job, not the best in the world, but they're generally a good lawyer, we usually call that lawyer up and say, look, this client has come to us, they want to fire you and hire us. If you would like, we will do that and just treat it as if you referred the case to us. And then we will give that lawyer a referral fee, which saves them the time and trouble and effort of filing an attorney's lien, which has to be tried at some later date. It's the way it is normally worked out.
Okay.
That's probably more information than you wanted.
But you know what? You helped explain what really happens behind the scenes, because a lot of times we don't know, but it is good to know that a client has the option, if they don't like their attorney, to get another one. That is good to know. So thank you for clearing that up.
You're still proceeding under the general principle that either way it should be for cause. I mean, sometimes lawyers fire clients, if they don't respond, if they don't respond to telephone calls or requests to come in. Oftentimes you say, well, I'm not going to expose myself to some kind of liability because the client won't cooperate with our office. So we just terminate the relationship.
Okay. Well, that's good to know too. So I hope everybody watching is paying attention. That's for sure.